All right, welcome back. We should be on a new feed, so we have another 8 hours worth of tape we can run. So, protein bars. Okay, Director Smith, we're going back to your motion. Director Forbes, the floor is yours.
Thank you, Chair Jen. Okay. The way this motion is worded, I have significant reservations and I cannot agree to it. I can agree to reviewing 5.08, but not the way this motion is worded. The ABA model rule was adopted in August of 2016. Since then, through my personal research, I found that the United States Supreme Court has issued 2 opinions that lead me to believe it would likely be held unconstitutional. We heard from a constitutional scholar from the preeminent South Texas College of Law who raised persuasive, significant constitutional and other concerns. And we also received an opinion from the Attorney General echoing the concerns. Rather than for DCAP, based on all this, I believe that based on my fiduciary duty to the bar, this would represent misspent bar fees, including additional legal fees on researching the legality of it and the time spent. DCAP could spend its time on procedures in the grievance process that may lead to inequitable results for our African American, minority, and certain practice area colleagues. They are disproportionately affected. That time could be spent addressing those important issues that affect the daily practice of attorneys and the public's trust in our delivery of legal services. DCAP could also spend its time to educate lawyers and the public on the significant changes the legislature made in 2017 to the grievance process. So while I think it's a good idea to review the disciplinary rule 5.08 to narrowly and strictly tie it to what our purpose is, which is to discipline. I mean, our purpose under the State Bar Act is to discipline lawyers. So it needs to be very narrowly tied. So for these reasons, I do agree with Director Schrammick and Calvillo that a review of that 5.08 might be advisable, but I cannot agree to send 8.4G to DCAP. It would be a waste of resources. Thank you.
Thank you, Director Forbes. Director Hurst, the floor is yours, sir.
Thank you, Mr. Chair. And I sat here all day and listened to the amazing comments from the public. I've listened to the great research that Ms. Forbes has done and the advocacy of Mr. Schrannick, Mr. Calvillo, Ms. Forbes, and others. And I generally am in agreement with all 3 of them, with one exception. I do think that 5.8 is the place to address our concerns. I do believe that, well, I do have serious concerns about the possible constitutionality of 8.4 in light of the cases that I've heard. I do believe that in the interest of everything that we've been doing, in the interest of the public, that we should, in fact, refer 5.8 and 8.4 to the committee, to the DCAP committee, so that we may evaluate and let them do their magic in the chemistry room or the kitchen or whatever have you and make their recommendation. I think that we need to give them all tools at their disposal to evaluate, and that's where I leave that. So I am in favor of sending it to DCAP with the concern about the constitutionality and with my strong belief and support of what Ms. Forbes, Mr. Calvillo, and Mr. Schrannick say about 5.8 being the way to address it. Thank you very much for your time.
Thank you, Director Hurst. Director Bim.
Thank you, Chair. I believe that this referral is appropriate because it's so critical that we understand that some of the harassment that our membership endures is not part of an adjudicatory proceeding, but is often just part of an immutable characteristic that they have going through life. And when I found that there were allegations that a member of the Texas Bar had physically assaulted another member, not pursuant to an adjudicatory proceeding, but simply as a virtue of her sex, and that there was nothing in the state bar rules that would provide that those two people acting in their professional capacities who were not employer and employee, there was no relationship that would provide this person with any way to potentially call this attention to the bar. That disturbed me. It disturbed me greatly. And so I disagree with Rule 8.4G as it is written. I do believe that it is overbroad and would likely be held to be unconstitutional. But I do believe that we as a bar need to do better, and that we need to provide some relief in our disciplinary proceedings for activities that may not necessarily be part of an adjudicatory proceeding, as Director Schrammick said, but that may be a function of their work as a lawyer. And for that reason, I support this referral with the understanding, as others have said, that hopefully we can find some middle ground here. Thank you.
Thank you, Director Bim. I think Director Cortez Mares, Yolanda, the floor is yours.
Thank you, Chairman. For those of the members of the public that are not familiar with what 5.08 states, 5.08 is a Texas disciplinary rule of professional conduct, and it has two parts to it. Part A states a lawyer shall not willfully, in connection with an adjudicatory proceeding, except as provided in paragraph B, manifest by words or conduct bias or prejudice based on race, color, national origin, religion, disability, age, sex, or sexual orientation towards any person involved in that proceeding in any capacity. I won't read paragraph B, but paragraph A seems to be what we are all focusing upon. As a member of the DCAP subcommittee, I can say that DCAP does not need a motion to consider on its own any changes to, or any recommendations for changes to Rule 5.08. I am not personally in favor of ABA Model Rule 8.4G for the reasons stated by these other directors. But I am in favor of revisiting 5.08 of our own rules to determine whether or not there can be some improvement, as Director Schrammick indicated and Director Forbes has very eloquently indicated. But I do not believe that there's a motion that is needed for the DCAP committee to consider any recommendations in connection with 5.08. Thank you.
Thank you, Yolanda. Director Naylor, also the chair of the DCAP committee. You have the floor, sir.
Thank you, Mr. Chair. Sorry, I was trying to get it going. I agree with Director Forbes, and I agree that it would be a complete waste of time, a waste of state bar assets to spend all this time looking at the ABA rule. If the idea, and I agree, and in this sense, I agree with Director Cavillo and Schrammick and the others. But if the goal is to revise 5.08, why are we referring the ABA rule? Just refer us to the DCAP committee to look at Rule 5.08, or someone come up with a proposal for 5.08. If 5.08 has that many problems, why hasn't someone made this proposal already? But all the time and resources that the DCAP committee is going to be spending to start with the ABA rule and then start revising it and then merging the two rules, as Lucy Forbes, Director Forbes said, we could be using that for other things that are right now affecting our members. And as we have a fiduciary duty to our members to not involve them in litigation that is we all know we're going to lose, and not to waste their assets. We could be using this to focus on the diversity or the inclusion or anything else, but let's short circuit it and focus on the rule that everybody wants changed, or better yet, somebody give us a proposal for a change to that rule. Make the recommendation. So I will be voting against it. I hope others will, but you know, I'll accept the board's vote as I always do. But thank you, Mr. Chair.
I'm on mute. I apologize. Director Vinny Augusto. Oh, thank you, Steve. Director Augusto, you have the floor.
Thank you very much. I wanted to be very clear that I believe this motion is unnecessary. I am against the ABA Model Rule 8.4G, not because the Texas Attorney General said it's wrong, or not because of that opinion, but because I have studied it myself. We have heard opinions and thoughts here today, and because I have listened to people smarter than I that are professionals in constitutional law, like South Texas College of Law Professor Josh Blackman, and the United States Supreme Court opinions. And because they believe it is wrong, Professor Blackman gave us a very eloquent opinion about it today, and others. And then I listened to our member, Steve Naylor, and what he has just said. I'm glad I'm following you, Steve, because I believe it's unnecessary. I'm not in support of this. I'm not going to vote to send it. What I'm interested in is what Steve said, which is if we have things that need to be fixed, grievance reform that I believe is very necessary for us in this day, then we can deal with the rules we already have. The professional responsibility rules 5.08, it's already in place. Like others have mentioned, I also had the blessing of being a chair of a grievance committee here in Houston, and I saw firsthand some of the problems that come up with grievances that are filed and the limitations that lawyers have in defending themselves. So I am for grievance reform, and I believe wholeheartedly that the way to address some of our issues is in our professional responsibilities to deal with fixing those rules, and 5.08 is a good way for us to deal with. But that's not the motion we have. What I do believe is that we have to deal with improving our Texas rules, bring grievance reform, which is something that is still before us as a duty and responsibility we have as board members, and listen to Steve Naylor and others that have said we're against it. And I am against it, and I'm voting against it.
Thank you, Director Augusto, for your comments. Director Almanzan. Andy, the floor is yours.
Yes,
whenever
sir.
You're off mute.
I appreciate it. Thank you very much. I personally am in favor of the referral. Again, we're talking about a referral. It's just the first part of the process. And with all due respect to everyone else that has spoken, it sounds like DCAP is probably going to, at least sua sponte, look at 5.08 anyway. All due respect, would it really hurt to also open up model rule 8.4G? Is this going to be like a gender reveal fire that's going to happen if they actually open up the ABA rule and look at it at the same time and in connection with looking at 508? I do believe that 8.4 is broader and has a more encompassing reach. Maybe that's problematic, maybe it's not. And even if the committee later or ultimately recommends adopting a modified version or a variant of the rule, that might happen too. But I don't think that it's that adverse or consequential to not even take a look at 8.4. It's almost like, let's just burn it already. I don't think we need to burn the book, and I don't think it would hurt to look at it while you're looking at 508. Thank you.
Thank you, Andy. Director Sergi, David Sergi, you have the floor, sir, whenever you're off mute. Oh.
So this is one of those rare times where I find myself in agreement with Attorney General Paxton. Very rare times. I think this is unfortunately ill-drafted, unconstitutional. It's vague, ambiguous, but there are pieces of it that might be savable. And so I'm in favor of reviewing it, but taking the best parts of it, because infringing on religious liberty, infringing on the thought that someone may feel compelled not to litigate or advocate for a particular purpose, regardless of how repugnant other people may see that to be. And I have to go back to the Supreme Court case of the National Socialist Party of America versus Skokie, where the US Supreme Court tells us, even if it is repugnant, you still have that right of speech. You still have that right to put forth those ideas in that marketplace of ideas. And so I do not want to have a rule that prohibits that speech, that religious liberty, regardless of how we look at it. So at the end of the day, I believe it is unconstitutional as drafted. I would be against referring the entire rule, but I think that we can pick it apart and make it better. So I would not vote for referring the ABA rule, but I would vote for amending and reviewing our current rule 504. Thank you.
Thank you, David. Excuse me, President-elect Sylvia Barunda Firth. I apologize. You're President-elect, not a director. Your floor, ma'am.
Thank you. Thank you, Charlie. I just want to say that I'm in favor of referring the matter to the DCAP committee because it's being done at the request of our membership. We seem to have a short memory about our last meeting where we heard from lots of people about this, the ABA rule. And while I tend to agree with everyone that as drafted, it's a problem. And I think that I don't think we're asking the DCAP to give us an up or down ruling on it. I think we're asking them to have a look at the rule. And as Director Sergi said, and also Schremek, let's pick what's the best from it and see if we can make it work within our system. So we're not limiting them to the constraint of the way the ABA drafted the rule. We're saying this is something we want you all to consider and come back with the best that's possible and legally supportable. I mean, we're not going to go out and do something reckless. So I am in favor of the motion with that understanding that the DCAP will have a broader look-see than just an up or down vote on the model rule. Thank you.
Thank you, Madam President-elect. Director Diane St. Ives. Diane, it's your floor whenever you unmute yourself.
Thank you, Chair. This issue is not one that we wanted. This is one that we were given unwillingly. We wanted to do grievance reform. We didn't want to have to spend our time doing this, but President McDougal has tossed this in our lap, and now we have to deal with it. We have to figure out how we can, going forward, solve these problems. We're only asking for the referral. 8.4G referred to DCAP, of which I'm a member, and we look at that in conjunction with 5.08, see what needs to be done and make recommendations. That is what is being asked of us, and that's what we have to do. We also have to do that in conjunction with our other jobs of grievance reform. This is something that needs to be done. President McDougal reached out to me on grievance reform before everything happened back in June, asked me to chair the task force, and I agreed willingly, wholeheartedly, and I am still there. But since June, I have not heard a peep from President McDougal about that task force. So this is one of the steps we have to take. Is it a waste of time? Absolutely not. Is it necessary? Absolutely. Is this whole issue, these special meetings, what we as DCAP members wanted to do? Absolutely not. But President McDougal has put us in this position, and we need to look at this and we need to do something to address these issues that are now in front of us and need to be addressed now. I yield the floor.
Thank you, Director St. Ives. Director Dawson, As soon as you unmute yourself, you have the floor, sir.
Thank you, Mr. Chairman. So I just want to reiterate some of what other people have said. Number one is we are not passing on the propriety or constitutionality of the ABA Rule 8.4 today. All we're doing is asking the DCAP committee to consider that rule along with 5.08 and determine whether any changes need to be made in the rules, and if so, to come back to this group, to this board, with whatever recommendations they may have. So I think it's premature to judge whether the ABA rule is constitutional or not constitutional. We should judge it when we get back from the committee whatever recommendation, if any, that they make. So I support the referral, and I look forward to hearing the results of their work.
Thank you, Director Dawson. Director Steve Fisher, you have the floor, sir. Steve, you're muted.
Right. There was very convincing arguments that we shouldn't refer this because of the waste of time and resources. But I really believe we're only going to spend probably about an hour on it before we realize that it is, as stated, it's not going to work. So good arguments, but I'm still in favor of it. Thank you.
Thank you, Director Fisher. Director Harris, Public Member Harris, the floor is yours, sir.
Yes, I'm going to support the motion because I believe in the process. This is about trusting the process, letting voices be heard, thinking thoughtfully about what's in 8.4G, what's in 5.08, and how we can come up with something, if we do, that better serves both the members and the public. I represent the public on this board, and so that guides my concern. And I've heard everybody's comments in that regard. And I understand that 8.4G as written might serve as a chilling document for representation. But if there is something good that can come out of it that serves the membership and the public better than what we have now, then let's let the process discover that. I trust the process and I will support the motion.
Thank you, August. Immediate past president, Mr. Randy Sorrells, the floor is yours, sir.
Thank you. I'm confused on how to vote because I want the committee to do the very best they can on all the rules, not just this rule. So look at everything they should consider on all the rules to improve all the rules to make them better for Texas lawyers. I'm convinced we have a committee that will do that. So whether I vote yes or no, I don't know that that makes a difference because I think this committee is going to do their very best to improve all rules anyway, including this rule. Thank you.
Thank you, President Sorrells. Director Smith and then Morris, and then I think we've heard from everyone. Director Smith.
Thank you, Mr. Chair. I'm Jason Smith. I am a trial lawyer and board certified civil appellate lawyer since 1997 who's handled discrimination cases and civil rights cases. I'm very familiar with this area of the law. At the last meeting, at the July meeting, special meeting, we heard from more folks than we're probably ever going to hear from who were hurt and who by the comments of President McDougal and who thought that they were racist. They talked about problems and discrimination in the practice of law. We have a duty not only to protect First Amendment rights, but we have a duty to protect 14th Amendment right to equal protection of the laws and for individuals to be free from discrimination. I appreciate the comments of everyone who took the time to share their views. I think they had some good ideas. No version of Rule 8.4G should punish zealous advocacy by lawyers. But right now, it is perfectly acceptable under the disciplinary rules for a employer who's a lawyer with less than 15 employees to say he's going to fire someone because they're pregnant or because they're gay or because they're Black. It is perfectly legal for a lawyer to say, I'm not going to represent you because you're Hispanic. if we adopt Rule 8.4G and we make modifications to protect people, then we can have a better bar, and we can respond to the dozens and dozens of people who shared story after story about discrimination in the practice of law. Moreover, we can not crawfish on what we did. We passed this referral to another committee unanimously in July. But now we're changing, even though the language of 8.4G is not vague or overbroad to the extent it doesn't limit zealous advocacy. There is a body of case law that defines what discrimination is and defines what harassment is. That will be very clear. There were folks in 1964 who said that the Civil Rights Act of 1964 was vague. We've passed it, and we've developed standards that folks can follow. We need to take action so the public and the bar membership know that we, as the governing board of the State Bar of Texas, are willing to take action regarding racism, sexism, and other isms that unfortunately occur in the practice of law. As a Christian, and Christianity nor any of the other great religions condone discrimination. And so I don't believe that the right to worship the God that you please, certainly it is going to be used by anyone that I know of any type of faith or lack of faith as an excuse to discriminate. So I hope that everyone vote like we did before, votes to refer this for study. I hope we have a robust process where many of the people who spoke today provide their input and their good ideas, so we can have a full discussion and make sure we don't do anything that will have unseen consequences. But I don't think we should be scared off from standing up to discrimination in the practice of law as the membership and the public is demanded. I ask that you I ask that you support the motion to refer this to DCAP, and that we send the message that discrimination has no place in the practice of law in Texas.
Thank you, Director Smith. Director Morris, I'm going to give you the final comments on this, and then we're going to move it for a vote. You have the floor, Yolanda.
Thank you, Mr. Chairman. I call for the question.
Okay, I think it's best to do a roll call vote at this point. So I'm going to ask our executive director to lead us in that roll call vote. Trey, please.
Mr. Augusto.
Nay. No.
Mr. Allison. Mr. Almanzon.
Yes, in favor, yay.
Mr. Baruch.
Vote yes.
Ms. Bim.
Yes.
Ms. Brooker.
Yes.
Mr. Cavillo.
Yes.
Mr. Luis Cardenas.
Yes.
Mr. Cook.
Yes.
Mr. Crane.
Yes.
Ms. Davis.
Yes.
Mr. Dawson.
Yes.
Mr. Docupil. Ms. Hernandez Ferrier.
No.
Ms. Barunda Firth.
Yes.
Mr. Fisher.
Yes.
Mr. Flores.
Yes.
Ms. Forbes.
No.
Ms. Goldsberry.
No.
Mr. Gravely. Mr. Harris.
Yes.
Ms. Harrison.
Yes.
Ms. Humphrey. Mr. Hurst.
Yes.
Ms. Cortez Matas.
No.
Mr. McDougall.
No.
Ms. Cara Miller.
Yes.
Ms. Mount.
Mr. Naylor,
No.
Ms. Rispoli,
Yes.
Ms. Rowe, Mr. Schrammick,
Yes.
Ms. Scott,
Yes.
Mr. Sergi,
Yes.
Mr. Sims,
Yes.
Mr. Jason Smith,
Yes.
Mr. Todd Smith,
No.
Mr. Sorrells,
Yes.
Ms. St. Ives,
Yes.
Mr. Tolchin,
Yes.
Mr. Vargas,
Yes.
Mr. Vasquez,
No.
Ms. Welborn,
Yes.
Mr. Wester,
No.
Ms. Pack Wilson.
Yes.
Okay, motion passes. All right. I believe there was a request for some discussion. I'm going to give the floor to Director Rob Crane. Director Crane, the floor is yours.
Thank you, Mr. Chair. I will cut my comments short. I hope it feels that way to you all. First of all, I just wanted to say thank you to the chair for your leadership, not just in this meeting, but in the meeting in July. I doubt there was another association in America on July 27th and today, September 10th, having the kind of open discussion from its members in the way that is transpired. It is inspiring to me. I hope it is inspiring to not just our members, but to other citizens in our state and throughout the country. We had over 60 public speakers in July. We had 45 today. And I thought it was a beautiful display of America and how we should conduct ourselves. Everybody, the speakers, following protocol and being respectful, and the board listening attentively. Mr. Apfel, thank you so much for your diversity inclusion comments and in your message, your written message to our membership. We are going to continue that work. Mr. Dawson, you and I have fought on some issues that were not necessarily popular in the past, and you and I agree on 99% of everything involving the comments made by the president and one of our directors that has caused these two meetings. Can't thank you enough for your comments today, your thoughtfulness today. And I just want to applaud you. I join your apologies to our members. And you said that and you put that on your shoulders, yet as all of us as elected directors, we're only directors for 3 years. And I know that you are not on the Elections and Nominations Committee when that meeting occurred. And I know you are not on this board when we failed to do the things we needed to do. But you put that on your shoulders, and you are a leader among leaders, and thank you for doing that. The process has been spoken about. We are 105,000 members. We have multiple governing documents. We have case law that we have to follow. We have a lot of eyes on us, and this board of directors has got to follow process. And I believe the process over the past 2 meetings has played itself out in the best manner possible. And you have served your membership incredibly well, whether we agreed on votes or did not agree on votes. I want to accentuate the positive for a minute on something that is so passionate to me. As many of y'all know, I'm a co-founder of Together We Dine, Together We Can. I work every day on human relations, which race relations are human relations. And the positive steps that are necessary in this state bar, you all are leading out front, and you all passed a number of motions in that last meeting. We've talked about a number of them. The task force, President-elect Firth is leading. I know that she's worked diligently in identifying candidates who have not necessarily been involved, but who are not white, who need to be better represented in our leadership. I know that Director Rowe in her task force has done the same. We were approached, Alan Sims and I, he's the advisor of the African American Law Section, and I'm his alternate, to whether or not we felt a resolution in support of the positive changes that need to continue to occur take place. And he and I felt, I don't want to speak for Alan, but he and I felt that recommending that to Ms. Rowe's work group would be a positive thing. And she called, she had to leave. That's why you didn't hear her vote. But she is going to bring that forward to her committee as to whether or not that's an appropriate task for them. In addition, we have got the board taking implicit bias training. We have the analysis of the African American lawyers section action items is underway in a positive way and moving forward. The nominations of new candidates for new positions as has been predicated about next board meeting on the 25th. We have a wonderful new candidate for a position, or nominee, I should say. And the to-dos, when the frustration came about of when things came down and we learned these comments by the president and the director, there was no code of conduct. There was no process for removal. There are these omissions that were in our system well before Alistair Dawson, and his motions today that passed to help fill that void are critical for this, critical for our membership going forward. And that positive work is what we need to continue to do. It is much easier to divide than to unify. And in our country, we know that now. And the lawyers, I believe, are uniquely positioned in our communities to be the uniters. And there's so many of this board and leadership here who are doing their best to unite in positive change in positive way. I just wanted to once again give my thanks and gratitude to all of the board members, and in particular, Mr. Dawson, and to Mr. Ginn, your leadership, and Mr. Apfel for guiding us through these two meetings. I know there's more work to be done, but I felt like it needed to be said about the positive things that have already come out of this negative instance, and let's continue to unify in a positive way.
Thank you, Director Crane, for your comments and for your leadership. I'll take two more, Director Augusto and Director Fisher, in comments, and then we'll move to the next item of the agenda. I believe our next item from the agenda will be a report from President McDougall. Director Augusto, you have the floor.
Thank you very much. I have a couple of minutes, and I wanted to be positive. I'm glad that Rob Crane used his time to be positive. I wanted to be positive. I'm positive in my everyday life with my beliefs and the way I do things. And we need to praise the leaders that we have in our group because Charlie, you've done a great job. Trey, in your leadership, and Alistair, in your leadership, you have really brought us to this special meeting today as members to not waste the time of the regular business time. So I'm in favor of having a special meeting so we can focus. We have the opportunity to have the members be heard and be deliberate and deliberate in what we have to do. Our goal as State Bar leaders is to find ways to help our lawyers and to help us in our practice of law, improve things in our practice of law. And we're doing that every day. So I want to compliment all of us to be positive. I believe in the First Amendment. I believe in due process. And I also believe in Texas. As lawyers of Texas, we're committed to be advocates to represent our clients, but represent the lawyers of our state. So I want us to continue to be positive in that. And so what have we seen and what have we heard? We have heard Larry McDougall, our president, say, "I'm sorry." We have seen him try to move forward doing his job. He's doing his job. And I'm one to say, even though I totally disagree and was disappointed by his comments, I'm one to say that I forgive. Let's move on. And we heard a lot of comments today, but what we heard today was we need to continue forward to do good for our members. And we have to do that. That's our job. So we see a diversity task force that's in place, grievance reform that's coming. We're moving forward with a lot of positive things, the task forces on leadership, on diversity. We have to look forward to positive things. And I believe that if we continue to look for what we can do to help each other as lawyers, then as directors, we will be successful. So I want to be positive and give us that opportunity to think we have work to do. We're going to be listening through the different committees. And I'm on some of the committees. In fact, I voted against the the referral that's coming to the committee that I'm part of. But I'm going to do my job no matter what. So I strongly encourage us to move forward in a positive way for the best of our state. Thank you.
All right, Director Fisher, I see that your hand is raised. You have the floor. Steve, you're muted.
I know. Okay. In line with what the last two speakers said, Benny and Rob, about unity and positive and working together, I have a specific suggestion, and it doesn't need a vote. Trey can say yeah or no. Obviously, we're discussing some really contentious, divisive issues where some of us, maybe me, are over passionate and zealous and really fighting. But what we're missing is the in-person meeting that we've always had. We've always had a retreat where we get together. When I first served as director, there are people like David Chamberlain or Harper Estes who never voted with me. Yet over the years, I've visited them, and we've had these friendships and communication. And some of the first year members have complained to me, and they said, we're having these fights and arguments. I've never even broken bread with these people. So my suggestion is that at the next in-person meeting, that we put an extra day in there. And we're certainly not, if it's Tyler, it's not really some exotic place that we would normally go. So, sorry, Christina, but that we can meet and spend some time. We don't have to spend a lot of money on it, but I don't even know some of these people I'm arguing with. And some of the first year members say, I haven't met 2/3 or 3/4 of them. So that's a suggestion. We can meet, we can talk, we can see what kind of differences we have in general. And I think it would be a good thing. Some of us are public persona or are combative persona. We may be actually nice people when you talk to us one-on-one. So that's my suggestion. No motion.
I know that we're all anxious to have coronavirus past us, and so we can all get together in person, not least of which for a board meeting, but so that we can all be with friends and family across the state and travel. There's no motion, so I don't see any reason to discuss the proposition, but I know we're all anxious for that to happen outside of our roles in the state bar. Our last comment in this discussion period will be immediate past President Victor Flores. Victor, you have the floor.
I just wanted to thank everybody for their comments. It's been a long day. I'm not going to insert any more arguments or issues, but I would like to continue the comments of being positive and going forward. And for those members viewing right now, TYLA remains committed to diversity and inclusion. TYLA has a history of creating projects that support that. I would encourage everybody to visit tyla.org and view all of our resources. One of them, which just recently, I think during the time of all of our discussions, received an award from the ABA Young Lawyers Division for its diversity project, one of its diversity projects of the year, which is the TYLA Retention Guide, not just including, but retaining a diverse legal practice so that our legal representatives represent are a fair representation of the clients that we advocate for. And also, I know that current TYLA President Brittany Harrison has already, even before all this happened, set up a line of diversity and inclusion projects way before the comments noted by our president and director. So we have been tasked, TYLA has been tasked with being the public service arm portion of the State Bar of Texas. We take that with great responsibility, and just know that for the members who are watching, the actions of these two individuals do not reflect. So just wanted to share that. And again, all our resources are available for free at tyla.org. I encourage everybody to visit that website.
Victor, thank you. And thank you for your friendship and your leadership of TYLA over the last 2 years and in this immediate past president year. And I know that both President-elect Janine Rispoli and Madam President Brittany Harrison, along with TYLA, are doing incredible things. And we're grateful to be in partnership with you. With that, let's go on to item number 8 of the agenda, a report from the President. President McDougall, the floor is yours.
Thank you, Mr. Chair. I'm going to keep this very short and save most of my comments for the 25th. But what I do want to tell you is I agree with about everything Benny just said, and I plan on moving forward. On the 25th, I plan on showing the roster and presenting my task force on citizen protection, grievance review, and the the client fund, where we fund, I've drawn a blank on the name right now, but have the roster in that committee and everything set up so we can hit the ground running and get going. I also plan on moving forward, introducing you to the work group on the courthouse access badges, if we'll ever need those again. And I also look forward to talking to you about the implementation of the plan that I've been working with Mr. Rob Crane on to address the issues of listening, the issues of inclusion. I always felt like when I made my appointments, inclusion was a big deal and it was very important to me. And I think if you look at him, you'll see that I did. So, but with that, I'm going to say the rest of my comments. I look forward to moving further. I hope we can put this behind us. And Mr. Chair, I give you the floor back.
Is there any comments or discussion based on the report? Seeing none, we'll move to the next item of the agenda, our report from the President-elect, Madam President-elect Sylvia Barunda Firth. The floor is yours. Sylvia, you're muted. There you go.
Okay, now you can hear me. Sorry, it's a long day, but I also want to echo the comments, Chairman Ginn, about your service to this group, and have been exemplary as a chair, and thank you very much. On one of our breaks, I looked on social media and I saw somebody called you a Texas treasure. So, so you have a new name, Chairman Ginn. I think I have the honor of having the last, no, maybe not. I think I have the last action item. So this relates back to July 27th, when the board approved the creation on the State Bar Task Force on Diversity, Equity, and Inclusion to study and propose actions to promote diversity, equity, and inclusion in the administration of justice and the practice of law. So when I drafted the proposal for this task force, it was not only to be advisory to the board, but also to help me to formulate my presidential initiatives relating to these topics. And at the July 27th meeting, I provided a description and the fiscal note with the understanding that I would be back today with the roster for your consideration. The roster includes 15 attorneys from across the state, and I want you to know that there was great interest in serving on this task force, and I'm very grateful for all of that interest, and I have saved all the names of the people that reached out to me. So even if you didn't make this task force, please know that we will use you as a resource before we're done. This is going to be the first step of many in working on these projects. Joe Escobedo of McAllen has graciously agreed to serve as chair if approved by the board. And the task force includes representatives from the following sections and standing committees of the State Bar: the African American Lawyers section, the Asian Pacific Interest section, the Hispanic Issues section, the LBGT Law section, the Native American Law section, the Women in the Law section, Disability Issues Committee, Diversity in the Profession, and Women in the Profession Committee. And I want you all to know that the appointments were made by those respective sections and committees. Some of them even had votes because they had people that were interested in serving. The remaining 5, also TYLA has, of course, has a representative, and he was appointed by President Harrison. The 5 additional members that I held back were done to try to fill gaps in areas that were underrepresented in State Bar leadership, either by geography or if I saw a missing special interest group. I was encouraged by several to make sure to take care of religious diversity as well. So in those 5, you will see that type of representation. And at this time, I move that the board approve the roster as presented on the Task Force of Diversity, Equity, and Inclusion, as was presented in your materials. I stand ready to answer any questions you might have.
I'd like to
Thank you, ma'am.
second that.
Okay, Director Sergi, skipping my comment, needing a second.
You got it.
Thank you, Director Sergi. It has been seconded. Is there any discussion? Hearing none, seeing none, we'll take a vote on this. All those in favor, please say aye.
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 Any opposed? Hearing none, the motion passes unanimously. Madam President, we are excited for your task force. We're excited for your year as president. We are grateful to have you, and we're excited for your leadership and for your service. Thank you for all that you do and for the work that you and your committee will be doing going forward.
Thank you, Charlie.
It's a great illustration of, I hope it's a great illustration. I believe that it's a great illustration of us listening to the board, us listening to the bar, and I know your hopes and dreams before this ever happened, these circumstances ever happened, this was your plan, and I think that's a great reflection of who you are. We're going to take one item out of order before we go to immediate past president Randy Sorrells, and that is, and I think it's going to be very quick, from our general counsel, Ross Fisher, whom I believe there is no report. Is that right, Ross?
That's correct. Yes.
Thank you very much. I appreciate it. That's number 13. So let's go back to, we've already had item number 11. So item number 10 is a report from the immediate past president, Mr. Randy Sorrells. Mr. Sorrells, you have the floor, sir.
Thank you, Charlie, and appreciate all you've done. I noted your 7 on your lapel, which is, of course, support for the 7th Amendment, and I appreciate and support that as well. I'm going to report about and talk about 2 things. First, what it means to Texas lawyers if we lose our autonomy, because there's been discussion since this divisiveness has raised its ugly head that we should do away with the Texas bar. And secondly, I'm going to address some of the issues, some of the Steve Fisher issues that have been raised. So first, let me talk about Texas. California used to be a unified bar, similar to Texas, and they decided to have a voluntary bar. What that means now is there is still some authority or some entity in Texas, in California, that licenses and regulates the lawyers of California. And since their change, their dues have skyrocketed now and are just for licensing and regulation. So you have an entity that licenses and regulates, which Texas would have as well if we dissolve the bar. And in California, those dues are $554 a year, and members get 0 benefits from that. Now, California lawyers can join a California state bar and pay more money for that and get some great benefits that their bar offers. But just for the licensing and regulation, $554 a year. Right now in Texas, we pay $235 a year in annual dues. That figure hasn't changed in 29 years, since 1991. And while some of our lawyers I know do not take advantage of the member benefits and member services the state bar offers, tens of thousands of lawyers do. And our lawyers' families and even the public take advantage of our benefits as well. I could detail all the programs out there, such as insurance benefits or TLAP. I think the Client Security Fund was mentioned earlier. Our support for our practice area sections, where we have, I asked this morning what the numbers were, 44,428 Texas lawyers participate in Texas State Bar sections, which is 42% of our membership. So those who say, let's just do away with the unified bar, need to understand what they're asking for. Higher dues, no benefits. So fighting for the State Bar of Texas, for a better State Bar of Texas, is what we should all be doing as we move forward. And in California, let them do what they want to do over there. But in Texas, let's be what someone else wrote today, one of the best bars in the country. And that person looked at it from a nationals perspective, from an ABA perspective. So let's try to improve. Now, let me second talk about Mr. Fisher's comments. When I appointed Steve Fisher to the State Commission on Judicial Conduct, I sat down and had a talk with him about his ability to be professional while still being a passionate advocate for causes like transparency and educating our members on the role of the commission. He assured me he had the ability to do this. I knew Steve had a background of being helpful to many lawyers, to recruiting lawyers to become more involved in the organized bar, and promoting the benefits of the organized bar while still maintaining his vision for what he thought was best for the bar. We didn't always agree on every issue, but we disagreed in a civil manner. Over the last couple of months, though, Steve's conduct has become quite erratic and unbecoming, not only of a director of the State Bar, but also as a lawyer of the State Bar of Texas. And these are not in areas of public concern or public interest. These are dealing with our colleagues. I'll give you some examples. In July 17th, 2020 Texas Lawyer article about his social media exchanges with fellow lawyers, he is quoted as saying, quote, "Sometimes I enjoy taunting them so they get angry at me." He went on to say, quote, "I get overpassionate and sometimes I feel bad later." Well, taunting is a form of bullying, and all of us have learned the destructive effects of bullying, and we should not tolerate it. The fact that a person cannot control his or her passion is no excuse. Feeling bad later does not undo the taunting previously done. Second, in a July 28th 2020 Texas Lawyer article about what the writer described as Steve Fisher's offensive Facebook comments, Steve admitted to being in temperament online. He again discussed in the article the controversy surrounding Larry McDougall, saying, quote, "I told Larry, I'll deflect, I'll get some of these comments and you just get better." Then he said this amazingly, "I went on there and I was pretty vicious. Being vicious to our colleagues in the profession is unacceptable. I believe Steve's efforts to help Larry McDougall were harmful not only to Larry, but to the entire board of directors and the bar as a whole. I have privately talked to Steve and told him that his conduct of name calling and intemperate language, as he described it, was damaging for the profession and our bar. He acknowledged what I said and he agreed to improve. And I thought there was hope. At the specially called meeting, though, on July 27th, as reported in the Texas Lawyer, he said, "I need to be careful about what I say, I really do. I need to look and say, hey, calm down, write it out before you post. Where I felt I did wrong, I do apologize. I need to work on it, and I have been working on it." But my hope faded over the last few weeks. Even this week, as I read through the comments submitted for this meeting, I saw Steve Fisher has said these things. Number one, to a lawyer, "You are always ignorant, dishonest, and wrong." To another lawyer, he said, "Illiteracy is a bad thing. Reading is important. You should change no schools to show on your profile to obtaining GED eventually." To another lawyer of Hispanic heritage, he noted, "Juan, you're, Y-O-U-R, and you are, Y-O-U apostrophe R-E, are different. You're an ignorant because your parents never cared enough to teach you English." I looked at what one of our members wrote, and I don't know if you all saw this, but I thought it was pretty insightful. He said, "Mr. Fisher, on the other hand, has become completely unhinged. Not only was his behavior in July 27, 2020 meeting completely unacceptable, but he has engaged in an ongoing campaign of dishonesty and aggression since that time. I know many of the directors are already aware of Mr. Fisher's lies, but for a small sampling, they include publicly, 1, claiming Mr. McDougall did not write his video apology. 2, claiming Mr. McDougall was forced to give his video apology. 3, claiming Mr. Fisher was working on or had reached a behind-the-scenes deal to address Mr. McDougall's controversies. 4, misrepresenting the motions raised at the July 27th, 2020 meeting. 5, misrepresenting various policies and procedures within the bar, including its committees. All of this occurred in addition to Mr. Fisher's continuing bullying, belittling, and attacking of his fellow attorneys, particularly female attorneys. I know at least some of the directors have seen this behavior because they've attempted to correct Mr. Fisher's lies publicly. I've talked to Steve privately, and I want to make sure people know publicly. All of Steve's efforts to focus improving on the bar have now taken a backseat to his conduct. Steve needs to take his own words to heart, and every time he writes anything out, he should say, "Hey, calm down, write it out before you post." Taunting lawyers, being vicious to our sisters and brothers in the law, name calling and insulting are all harmful. Steve can do better, and as a board member, he must do better. I have personally seen how the actions of the State Bar Board of Directors directly impact the practice of law. Those who liken our board to a high school student council are ill-informed and simply do not comprehend the magnitude of decisions this board makes year in and year out. When I roll off the board at the end of this year, I know how much my professional life will remain in the hands of those board members who remain on this bar board and those who come forward in the future and lead our state for years to come. I have 2 kids who just started law school, so I'm invested in this bar not only for myself, but for future generations as well. I know each of you take your job seriously, and I believe Steve does too. But for now, I'm asking Steve to adhere to a code of civility, even if others don't. I'm asking Steve to rise above the petty bickering, the childish name calling, and work together with your fellow board members to consistently improve the bar. Treat your fellow lawyers with respect and dignity. Step away when the urge arises to lash out. And if Steve cannot do this, or any of us cannot do this, resignation is the best solution. Each of our districts and the lawyers of our districts deserve someone who has a temperament better to construct our profession, not destruct our. I'm not sure I have the authority to do this, but I welcome any questions, comments, or feedback. My 1 year as president flew by, and Mr. McDougall's will as well. We will survive for those who've been offended by Mr. McDougall's comments, apologies, actions, or interactions. You have a right to feel that way, but we will survive this year. People did not agree with me during my year, and we survived my year. I heard someone say earlier, we don't want to throw the baby out with the bathwater. I went ahead and looked up that term after they said it, because I've used it before. It says to discard something valuable along with other things that are essential or inessential or undesirable. And I may have said some things that are seen as inessential or undesirable when I was president, and maybe Mr. McDougall has as well. But let's not throw the baby out with the bathwater. Mr. McDougall has proposed some programs that will help make our bar better. Let's get behind those programs. President-elect Sylvia Firth has already put some initiatives in place that will make our bar better. Let's get behind those. And let's make sure we go together as one bar, as a unified group, listening to all of our members, allowing everyone the right to speak and be heard, and move forward in a positive direction. Thank you, Mr. Ginn.
Okay, thank you, President Sorrells. I'm going to allow some discussion on this. Steve, I know your hand is up. I'm going to let you respond. When we do this, I'm going to ask that all comments be directed towards me. I'm not going to limit the comments in time. I am going to ask that they do not become abusive in either time or content, okay? With those understandings, Steve, you have the floor. Steve, if you'll unmute yourself.
I guess this descended into personal attacks, and if that's what you guys want, that's fine, Randy. I always was taught to treat people the way people treat you. And yeah, I should ignore a lot of these comments. Well, let's take one of them, that Steve was drunk, sitting in his car, drinking beer, during that meeting. And that and even Andrew said, and he was in a car. Well, that meeting probably cost me $10,000. I had stuff to do. I had planned that meeting, my trip, way before this emergency meeting, and I don't think I've been drunk in my whole entire life. So I hear stuff like that, and yeah, and then I wrote a series of about 5 or 6 columns, different papers printed it, and someone whose only comments are on Facebook said, well, those aren't really great newspapers. Well, I thought they were, and when I wrote it, initially the bar censored it. The bar should not be against free speech. And they have a daily news clipping, and they send out all the articles, and yet, hey, what happened to mine? Lufkin paper wrote it, the El Paso paper wrote it, the Midland paper, whatever, and they go, well, and you said, Randy, that you didn't agree, that you thought that some of that stuff was untrue. There's a way to deal with that. When someone writes, and then people didn't know the difference between a column and an article, people said, look at that headline. I tried to explain journalism 101, maybe I should give a CLE on it, that when you write a column, you do not put a title to it. That's why each column in each paper was different. So yeah, I get offended of what I do see as ignorance, and I'll say it. And these are, every attack that someone makes on Larry, I take it personally too. And I'm really disgusted with the way the bar has not moved forward on any of the things that we're elected for. So yeah, sometimes later I think I shouldn't have done that, and I really should not, indulge. There's about 5 or 6 people that wherever I post on Facebook, they're there to say something insulting, and I probably should be the better person. But you know, it is what it is, and somebody attacks me, I usually fight back. And if they attack Larry, when Larry's fully recovered and healthy, then I can step out of this conversation, and Larry can deal with it himself. But I find things when he's in the hospital and people demanding, well, Larry, why isn't Larry answering that? Well, you know, he happens to be in the hospital. So yeah, there's truth in that, Randy. There's truth in that. And I can always try to be better, but some of the malicious, libelous, disgusting comments that people make, you know, I was drinking bubbly water, which tastes almost as bad as beer. So yeah, and I had to be up there. Why was in my car? Because I couldn't get reception up in a place that's miles from internet, and I was just lucky to get on there at all. So yeah, you know, I'm pretty much a fighter, and people attack, and they'll get that in turn. But I do appreciate your comments in that the parts that we're trying to be constructive, but I really don't want to sit here and argue over these comments all day long. Thank you.
Thank you, Director Fisher. Director Tolchin, you have the floor.
Hi, Charlie. I'll address this to you. One of the things that we can do as board members is represent ourselves honestly as to who we are. And I would discourage anyone who's on the board from using, for example, their wife's account to discuss bar business or anything of the sort without being known to actually be an account operated by a member of the board. No, I'll leave it at that. Thank you.
Thank you, Director Tolchin. Director Forbes, you have the floor.
Thank you, Mr. Chair. I want to thank our colleagues and the public for their participation and priceless feedback. I agree we should move forward in a positive manner, working together to promote the State Bar of Texas mission statement, which we'll read together at the end of the meeting.
Thank you, Director Forbes. With that, let's move, if there's no other discussion, to item number 12, the Executive Committee Nominations and Elections Subcommittee. Immediate past President Randy Sorrells and immediate past Chair Jerry Alexander, the best dressed man in the bar. The floor is yours.
Jerry, I don't mind doing this, but I just spoke. So if you want to do it, you're welcome to.
Oh, no, go ahead.
Thanks. A very brief report. Hopefully that's good news from the Nominations and Elections Subcommittee, for which Jerry played a huge role. In fact, all of our members did, and spent a lot of time going through the nominations process. And Jerry was a wonderful leader, and appreciate his leadership. We conducted interviews on August 21st. We interviewed 9 people for the president-elect position, 9 outstanding candidates, the best slate that I think I've ever seen. Each of the interviewees did a tremendous job, and all of them would do a fantastic job as president-elect. At that time, the subcommittee selected Laura Gibson of Houston and Leon Carter of Dallas as its nominees for president-elect. We had sent communications to the board updating you on this fact. Subsequently, Leon Carter determined that now was not the right time for him to personally make this commitment, and so he decided to withdraw his name from consideration. The subcommittee met again to consider our approach for nominations given this development. We then voted to select Sarah Dysart of San Antonio, and will recommend both Ms. Dysart and Ms. Gibson to the board on September 25th. At the last special board meeting on July 27th, the board requested the Nominations Subcommittee and Policy Manual Committee to consider proposing revisions to the board policy to provide increased vetting of president-elect candidates. We've asked the Policy Manual Committee for their input, and we'll be working with them to look at what policies we can incorporate in the vetting process. In the meantime, we required the 9 candidates to submit certification form to us to let us know about whether there was anything controversial in their background. We also included new questions during the interview process to obtain more information about a nominee's background. Again, we remind people, if you wish to run for president-elect of the State Bar of Texas, you can do so through the petition process. The president before me, Joe Longley, ran through as a petition candidate and won. So it's doable as well. So we encourage anyone interested to consider the petition process as well. That concludes our report, and we'll be back at September 25th meeting to present the nominees for your consideration.
Thank you, and I will echo that both Randy and Jerry did an exceptional job leading that committee, and we appreciate the work and the time of our leaders in that and the other committee members. With that, we'll go to item number 14, which I anticipate will be brief, our report from legal counsel, Mr. John Sermon.
I have no report.
Thank you very much. We are not going back into closed session. We did all that earlier. We're going to recite we're just about done. So we're going to recite our State Bar of Texas mission statement. I've asked President-elect of TYLA, Janine Rispoli, to lead us in that. And before we do that, I just have a few things to say. To the members of the public, thank you for sticking with us on another long meeting. To our directors, thank you for being here, for setting aside days of your practice to be here in service and leadership. To the members of the bar and the members of the public, I want you to know that typically we have 4 meetings that are set out a year for us to come and address the needs as a board. And we've had now 2 special meetings called. We did that because we wanted you to know that we are here and that we want to do whatever we can to help you and your practice of law and to protect your ability as lawyers. Not every decision we make will be satisfactory to everyone. We can't fix every problem, but we are here to help. We do want to help. I don't know of a single director on this board that truly doesn't want to serve Texas lawyers. Keep talking to us. We're going to keep listening. We're going to keep fighting for you. That is not going to stop. Our staff here at the State Bar, any compliments towards me or anything else is appreciated, but I want you to know that anything you're seeing up here that you think is halfway decent is truly because of the staff of this bar. Trey Apfel, Chelsea, Jennifer, Ray, John, Kaylin, our staff is without equal. They are incredible. They have worked around the clock now, not once but twice, for 2 special meetings, and they've got another meeting coming up in 2 weeks. And they do it because they have a true desire to serve. There are good workers everywhere, but these people care. And so I want our board and our bar staff, our bar and the members of the public to know that they are blessed because they make all of this happen. Otherwise, we would be in a pandemic and we would not meet and we would not get anything done and we would be stagnant. Instead, we're anything but that. So I want to thank you to our directors for that. Thank you for our officers. Thank you to our staff. And we will hear from our members of the public again on the 25th. We're ready to hear from you. We're ready to keep working. Janine, if you would lead us in our State Bar mission statement.
Charlie, thank you for being a wonderful servant leader today, as you always are. Our mission, the mission of the State Bar of Texas
is to support the administration of the legal system, assure all citizens equal access to justice, foster high standards of ethical conduct for lawyers, enable its members to better serve their clients and the public about the rule of law, and promote diversity in the administration of justice and the practice of law.
It is 5:28 p.m. and I will entertain a motion to adjourn.
Motion to adjourn.
Second.
All right. I don't know who said it, but I think Diane's saying I've said it, and I'm going to assume that Michael Hirsch seconded it. So with that, we are adjourned. God bless you all. Thank you for being here. It is 5:28 p.m. Thank you.